Hello, this is Professor James Strickler, and this is a course in American government. This lesson is from Unit 8 about civil liberties. It's Lesson 6, dealing with selective incorporation. And I'm going to warn you right now, this is one of the most difficult ideas that you'll learn during this entire course. So this lesson may be a little bit more long and complicated than some of the others. In this lesson, you'll learn about the United States Supreme Court case of Barron versus Baltimore. You'll learn about state bills of rights. You'll learn about the Supreme Court case of Gitlow versus New York. You'll learn about the idea of selective incorporation. And you'll learn about unincorporated rights. So let's begin with the Supreme Court case of Barron versus Baltimore. In that case, there was a man named John Barron who owned a wharf in Baltimore Harbor. He blamed the city of Baltimore when his wharf became unusable because they had diverted a stream that then deposited silt around his wharf. They diverted it so they could build a street. On the left of this slide, you actually see a map of Baltimore Harbor at the time and the consequences of them rerouting the streets. So John Barron sued the city of Baltimore. He went to court and he claimed that they had violated the Fifth Amendment of the United States Constitution, which says that private property will not be taken for public use without just compensation. Now, we've seen the Fifth Amendment before in this course. You may recall that it has more things in it than just this. But this particular provision is that before the government, or I should say when the government takes property from you for government use, they have to pay you for it. So John Barron was essentially arguing that in them constructing this new city street, they had in effect taken his property from him by putting silt into the bay that made his wharf unusable, and therefore they should have to pay him for it. Now, in making this argument, though, he is saying that this provision of the Fifth Amendment should be read in a way that it restrains what the state of Maryland can do through the city of Baltimore, not just what the government of the United States can do. Whether this is a legitimate argument or not, we have to consider something about the history of the Bill of Rights. The Fifth Amendment and the rest of the Bill of Rights were added to the Constitution because of concerns, particularly among the Anti-Federalists, that there weren't sufficient protections to stop the new national government that was being created by the Constitution from becoming tyrannical, oppressive, evil. And so they wanted some extra protections in there to restrain the powers of the national government. That's why the Bill of Rights was added. It wasn't added to restrain the powers of the state of Maryland or the city of Baltimore. It was added to restrain the powers of the national government. Then if we look at the actual language of the Bill of Rights, we'll see that it begins with these words in the First Amendment. Congress shall make no law. Notice it doesn't say state of Maryland won't make any law or city of Baltimore won't make any law. This is a textual indication of what the Bill of Rights was intending to do. It was intending to restrain the powers of the national governments, not the states. Did I say plural national governments? I meant national government, not the states. And that's what the United States Supreme Court in the case of Barron versus Baltimore ended up ruling. They said that the Fifth Amendment has to be understood as only applying to the national government, not to the state governments. Now notice the date of this case, 1833. This is only about 40 years after the Bill of Rights was added to the Constitution. It's still a fairly fresh thing in the minds of Americans. They're still sorting out exactly what things mean. And so this was a very important Supreme Court decision. It's important because it established this principle that then applied not just to that one clause in the Fifth Amendment, but to the entire Bill of Rights. And that is that the Bill of Rights only restricts the power of the national government. It does not restrict the power of the states. So while the Bill of Rights might say that you have freedom of speech, that means the national government can't take away your freedom of speech, but the state of Texas can. While the Bill of Rights may say that you have the free exercise of your religion, that means that the national government can't infringe upon how you practice your religion. It doesn't say whether the state of Connecticut can. And so states were essentially free to do all these things if they wanted to. And in many cases, states did do these kind of things. For example, in the area of free exercise of religion, at the time the Bill of Rights was written out of the Constitution, states all had official religions of one sort or another. Some of them had official churches that were supported by tax dollars, and none of those things were considered unconstitutional because of the addition of the Bill of Rights. The Bill of Rights only applies to the national government, not to states. That's one thing that most Americans don't even understand. So does that mean that the states are free to do whatever they want to take people's rights away? Well, no. And the reason is that there are two ways in which your rights are protected by states. The first one is state bills of rights, which we'll talk about in a moment. This is the original way, the way that was in effect in 1833 when Barron versus Baltimore was decided. The second way is a concept called selective incorporation, which is a fairly new invention of the United States Supreme Court, which we're going to talk about in detail later in this lesson. But let's first talk about the original mechanism to prevent states from infringing upon people's personal rights. Each state has its own constitution. And remember, the point of a constitution is to set boundaries and limits on the powers of governments. Here's an example of a Bill of Rights contained in a state constitution. This is from the state of Georgia. Georgia's constitution is the most recently written one of any of them in the United States. It was put in effect in 1982. It's had constitutions before that. It just wrote a new one. And you can see that it begins, Article 1, the very first part of its state constitution. Section 1, the Bill of Rights is how it begins its constitution, and that is true of many states. Because remember, this is something you were taught earlier in the course, the national government is a government of limited enumerated powers. And so there's an assumption if we don't give it powers, then we assume it doesn't have them. State governments, however, are governments where they have broad police powers, a general grant of power, kind of do whatever you need to do to take care of the health, welfare, and safety and morals of the people. And so limitations on that power have to be expressly made. And so that's how most state constitutions begin, with lists of things that they're not going to let their government do. They begin with bills of rights. And so you can see here the Georgia Bill of Rights begins with a provision that says no person can have their life, liberty, or property taken away from them except by due process of law. This is a due process clause, like we've already seen in this course dealing with the national government, that is found in the Fifth Amendment. So anyway, states have their own constitutions with their own bills of rights that protect people's rights. That is the first and most important way that people's rights are protected at the state level. But there's a second way that's been invented by the United States Supreme Court called selective incorporation. The reason we have this second way is because the United States Supreme Court just didn't like the fact that states were not restricted by the National Bill of Rights. Yes, they had their own bills of rights, but their own bills of rights were interpreted by their own state Supreme Courts. And the National Supreme Court didn't like how the states were doing that. The state Supreme Courts were allowing things that the national government thought shouldn't be allowed, or restricting things that the National Supreme Court thought shouldn't be restricted at the state level. They wanted to have control of what states could and couldn't do. They wanted to force states to obey the National Bill of Rights, which the United States Supreme Court, controlled and could decide what was in there. So what they had to do was hunt around in the Constitution for some place somewhere that they could take a passage and reinterpret it as giving them the power to force the states to then obey the National Bill of Rights. And where they finally settled on something can be seen in a Supreme Court case from the 1920s. That case is the case of Gitlow versus New York from 1925. This is where they began the process that became known as selective incorporation. It was a process to allow the Supreme Court of the United States to force states to obey the National Bill of Rights also. But while it began with this Supreme Court case of Gitlow versus New York in 1925, it didn't really get going until the 1950s and 1960s and 1970s, when the Supreme Court did most of what you're going to understand as selective incorporation here in a few moments. Okay, so this case of Gitlow versus New York from 1925 involved a man, Benjamin Gitlow, who was arrested and put on trial by the state of New York for publishing and giving speeches advocating the violent overthrow of the government. He was a communist and wanted to have a communist revolution, beginning there in the state of New York. When he went to court, and his case was eventually appealed to the United States Supreme Court, he made the argument that he had freedom of speech that should be protected against the state of New York, what the state of New York was doing to him. And this plays into the thing I was telling you about, that the United States Supreme Court wanted to have a way to make these decisions in place of the decisions that the states were making. So in this case, what the Supreme Court says on this slide, a very important quote in our constitutional history, the Supreme Court says that they are going to assume that freedom of speech and freedom of the press are personal rights or freedoms that are among the liberties protected by the Due Process Clause of the 14th Amendment. Now notice what they're saying. Okay, we got this idea of freedom of the speech and freedom of the press that are in the First Amendment. And the Supreme Court is going to assume that they're among the things that are protected by the 14th Amendment. All right, well, what's the 14th Amendment? You've seen the 14th Amendment in this course before. Let me remind you of it. The 14th Amendment begins with the words, "No state shall." Now, notice how this is different than the beginning of the First Amendment that says, "Congress shall not." The First Amendment, by saying Congress shall not, is obviously about what the national government can do. So when the First Amendment says Congress shall not abridge the freedom of speech, it's saying that the national government can't infringe upon your freedom of speech. The 14th Amendment, however, begins with "no state shall." So it's talking about what a state can do, including the state of New York. It then talks about, as you go down through the amendment, you get to a part where it says that no state shall deprive any person of life, liberty, or property without due process of law. What the Supreme Court then did was it said, you know what? The state of New York isn't allowed to take away someone's life, liberty, or property here, which traditionally has meant that they can't execute people, they can't imprison people, they can't fine people without going through certain fair processes to do so. But we, the Supreme Court of the United States, think that that word liberty may mean more than just staying out of prison. If the state of New York takes away your freedom of speech, have they taken away some of your liberty? Well, yeah, maybe so. And in that way, we can say, hey, state of New York, if you're not supposed to take away people's liberty, you can't take away their freedom of speech either. So you can see what they're doing here through this thing that became known as selective incorporation is they are reading portions of the Bill of Rights into the Due Process Clause of the 14th Amendment to thereby make them applicable to the states. That's the definition of selective incorporation. Now let me go through it again to make sure you understand. They're focusing on the 14th Amendment, which says what states can and can't do. And then they're looking at that word liberty in the 14th Amendment and say, well, liberty means more than just staying out of prison. So maybe liberty means freedom of speech also, like in the First Amendment. Well, by doing that, effectively what they're doing is they are selecting that idea of freedom of speech from the First Amendment, and then they are incorporating, or in other words, adding it to the 14th Amendment via that word liberty. Now, I know this is a very difficult concept to understand because in some ways I'm going to talk about in a few moments, it makes no sense. But this is the way, the sort of the trickery of reinterpreting and stretching meaning of things that an activist Supreme Court engaged in to allow them to then apply the provisions of the Bill of Rights against the states, to force the states to obey the Bill of Rights also. Now, it's called selective incorporation because they did it one little piece at a time. Here in the Gitlow case, they're suggesting that freedom of speech and freedom of the press are selected and then incorporated against the states through that word liberty in the Due Process Clause of the 14th Amendment to then force states to obey those provisions also. So if we look at the Bill of Rights, all its various provisions in its various amendments, we can then chart out what things have been selectively incorporated eventually by the court and what haven't. The most recent act of selective incorporation took place just a couple years ago. So you can see it began in 1925 and has moved up all the way to the 2010s. This is something that's been going on for 90 years now, that the Supreme Court has been picking and choosing little pieces of the Bill of Rights to then read them into the Due Process Clause of the 14th Amendment, to then force states to obey them also. So when we look at the Bill of Rights, now let's look at it as a list of things that can be incorporated against the states. Now, first thing we need to do is eliminate the 9th and 10th Amendment. You may recall from when we talked about them earlier in the course, the 9th and 10th Amendment really aren't about personal rights. They're not about you have a right to do this, have a right to do that. Instead, they're about general sorts of principles about that, oh, you have unenumerated rights. Oh, any rights not given to the national government are kept by the people or by the states. Notice they're general concepts rather than talking about specific things. So we're going to kind of set them aside as not needing to be incorporated. Then what we do is we have 4 amendments that have been eventually entirely incorporated by the Supreme Court against the states. The most recent was the 2nd Amendment about the right to bear arms. But piecemeal, a little bit here, a little bit there, eventually every concept from these 4th Amendments was applied to the states by the United States Supreme Court via this doctrine that we call selective incorporation. The 5th and 8th Amendment have been partially incorporated. The 8th Amendment has been incorporated in every way except no excessive fines. Potentially a state could still have excessive fines. And the 5th Amendment's been incorporated entirely except for the requirement of a grand jury. Potentially states don't have to have grand juries. But everything else in those amendments has been incorporated. So what we're left with is the 3rd and 7th Amendment. So let's kind of flip things around then and say, okay, what has not been incorporated? In other words, what rights are unincorporated? The entire 3rd Amendment has not been incorporated, which is about quartering of soldiers. And the entire 7th Amendment has not been incorporated, which is about that you can bring lawsuits for anything less than $20. So, yes, a state doesn't have to allow lawsuits for less than $20. And theoretically, a state could still quarter soldiers in people's houses, although the reason that's never been incorporated is because no states do that. And so nobody's bringing a lawsuit to complain about it. And then, of course, the 8th and 5th Amendments still have partial things that have been unincorporated. Okay, so now to understand where this doctrine of selective incorporation really fits in, we need to build another chart. So here's the blank chart that we're going to build. And let's begin with what's going to be in the rows. We're going to have things that we want protected against the government. When I say the government, I mean either the national government or the state governments. We want our civil liberties protected. We also want our civil rights protected. Then the columns represent the things that we're protecting them against. We're protecting them against, on the left column, the national government, on the right column against the state governments. Now, since protecting civil rights is the subject of the next unit that we're going to set that aside for now. We'll actually finish creating this chart when we get to our next unit about civil rights. But for right now, we just need to fill in the one row. So now let's look at the cell below national government and across from protecting civil liberties. Essentially what we're going to say is, how are civil liberties protected against the national government? That is done through the Bill of Rights. So if the national government is infringing upon a civil liberty, when you go to court, you say, they violated this provision of the Bill of Rights, whatever that provision may be. Now let's look at the cell below state governments and across from protecting civil liberties. In other words, if the state government infringes upon a civil liberty, what do you then turn to say the state government can't get away with that? This is where, according to the Supreme Court, through its doctrine of selective incorporation, the 14th Amendment comes into play. And in particular, we're talking about the Due Process Clause of the 14th Amendment, which includes that a very important word, liberty. So it's through selective incorporation, via the Due Process Clause of the 14th Amendment, that then states are forced to not infringe upon your civil liberties. So if you go to court and say, hey, a state has taken away my freedom of speech, or whatever it is, you're going to be using this doctrine of selective incorporation to make that claim. So, thing to remember eventually for a test is, if I were to ask you what prevents the national government from infringing upon your civil liberties, the correct answer is Bill of Rights. If I were to ask you what prevents the state government from infringing upon your civil liberties, the correct answer is selective incorporation, due process clause, that sort of thing. Okay? Now, a way to understand this is to consider this hypothetical situation. You have a protester out complaining in some way about the government, whatever it does, and a police officer comes up and arrests them for their protest. At that point, let's say it's a police officer from the state highway patrol or whatever it may be, state police. At that point, the protester could say, "Officer, you're violating my First Amendment right to free speech by stopping me from engaging in my protest." If the protester were to say that, technically they are incorrect, and you should understand why now. Because the First Amendment doesn't apply to states. Therefore, it does not restrict what that police officer could be doing. Instead, what the protester should say is, "Officer, you're violating my 14th Amendment right to due process, which the Supreme Court has interpreted as including the right to free speech, similar to that as found in the First Amendment." This is selective incorporation. This is the argument that the lawyer for that person would actually make when they go to court. So, if you want to be a smart aleck sometime when you get pulled over by a police officer for a speeding ticket or whatever, you can bring up that your rights are protected by the 14th Amendment. Show how smart you are. Now, actually, you probably shouldn't do that. But anyway, your rights are protected at the state level by the national Constitution via the 14th Amendment because of this idea of selective incorporation that the Supreme Court has invented. Now, I said before that in some ways this idea of selective incorporation makes no sense whatsoever. And there's two reasons why it makes no sense. One is that there's another due process clause, and the other is the very text of the due process clause, where it says with due process of law. So let's take this first one about there being another due process clause. In the Fifth Amendment of the Constitution, as just a small part of the Fifth Amendment, it says that the national government can't deprive you of life, liberty, or property without due process of law. This says the same thing as the 14th Amendment, but here it's about the national government, while the 14th Amendment is about the states. Now notice in the doctrine of selective incorporation, the Supreme Court is claiming that that due process clause of the 14th Amendment encompasses basically everything else found in the Bill of Rights. Well, if that's true, if due process clause in the 14th Amendment includes the entire Bill of Rights, then this due process clause in the Fifth Amendment includes the entire Bill of Rights also. But that's an absurdity, because it's part of the Bill of Rights. It's part of 10 amendments that were added to the Constitution. To claim that it covers all that stuff means that all those other amendments weren't even needed. That instead of a Bill of Rights, you should have just had a single due process clause put in the Constitution to cover everything. Well, they didn't do that. And the reason they didn't do that is because they knew due process doesn't cover everything. That's why they had to have all the other amendments. And so the idea of claiming that a due process clause includes all these other things like freedom of speech, freedom of the press, freedom of religion, etc., is absurd. It makes no sense. The second reason selective incorporation makes no sense is because of the text of the due process clauses themselves. Here's the text of the 14th Amendment. It's one. It says, "No state shall deprive any person of life, liberty, or property without due process of law." So let's assume for a moment that that word liberty actually does include freedom of speech, freedom of the press, all these other things. What this clause says is, hey, you know what, state, you still can take a person's freedom of speech away as long as you go through due process of law to do it. In other words, you go through fair procedures. You have a written law that says free speech isn't allowed. You arrest them properly. You have evidence against them. You have a fair trial with the jury. They get convicted. And you throw them in jail for having spoken when they shouldn't. As long as you go through the right procedures, you can take liberty away according to this. But that isn't what the Supreme Court did. As they have selectively incorporated these various rights from the Bill of Rights into the 14th Amendment, they've essentially crossed out the without due process of law part. They've said, well, yeah, okay, free speech is a liberty found in the 14th Amendment, and it's such an important liberty, we don't care what process, state of New York, you go through to take it away. No process is going to be good enough. You're not allowed to. So the Supreme Court, through their interpretation of adding the Bill of Rights to the 14th Amendment through selective incorporation, necessitated that they then cross out part of the 14th Amendment to make it work. So they added things in illogically, and then they unreasonably crossed out part of the amendment to do it. Selective incorporation makes no sense. Nonetheless, it's the law of the land because the Supreme Court did it. And why did they do it? Because remember, they just wanted to have some way somehow to force the states to obey the Bill of Rights. And they found a way to do it through this crazy doctrine of selective incorporation. So now let's review what you learned in this lesson. First, what did the case of Barron versus Baltimore rule? Does it rule that the Bill of Rights applies to states? Does it rule that states must give due process? Or that states can't take property? Or that the Bill of Rights doesn't bind states? Barron versus Baltimore ruled that the Bill of Rights does not apply to states. So how do states protect rights then? Do they do it through common law court decisions, by relying on the U.S. Constitution, by states having their own bills of rights? Or is it just that states don't protect rights? States have their own bills of rights. So what happened in the case of Gitlow versus New York? Did it rule that due process includes free speech? Did it rule that states must pay for property? Did it rule that states must have bills of rights? Did it rule that bills of rights are invalid in states? Gitlow versus New York, remember, assumed that due process includes the concept of freedom of speech. And that was the beginning of selective incorporation. So what does selective incorporation require? Does it require no quartering of soldiers? Does it require that states must add new powers? Does it require that states must obey the Bill of Rights, the National Bill of Rights? Or does it require that only some businesses have to pay taxes? Selective incorporation requires that states obey the National Bill of Rights. So through selective incorporation, which amendments have not been incorporated? I should say, which amendment has not been incorporated? Has the first not been incorporated, the second not been incorporated, the third not been incorporated, or the fourth not been incorporated? The Third Amendment about quartering of soldiers has not been incorporated against the states. The First, Second, and Fourth Amendments, however, have been incorporated in their entireties. All right, that completes this very long and very complicated lesson. I apologize for it being so long, but it was such a complicated idea that I couldn't really split it up into separate lessons and lose track of what we were talking about. So that does it for this lesson. The next lesson will also be from Unit 8. It'll be Lesson 7 about the limits of liberty.